Morning. Morning. We have two cases on the docket scheduled for oral arguments this morning. We will proceed in the order the cases are listed on the docket. Our first case is Anheuser-Busch Companies versus Staples. Counsel ready to proceed?
Yes. Yes, Sean.
May I proceed?
Yes. Thank you.
We've allotted 15 minutes per side for the oral argument. Counsel, would you like to reserve some time for rebuttal?
5 minutes, please, if possible.
So noted, Mr. Marshall. You may proceed.
To introduce myself, I'm Alice Fernandez, and I represent the petitioner and the defendant in the lawsuit addressed at the trial level. I don't know if the court requires or would like a brief rendition of the facts that have led up to here, but to summarize it quickly, this is a situation in which the plaintiff has sought to disqualify myself and my law firm from representation of the defendant because, as I understand it, the conflict was alleged, which the trial court found existed as well, and disqualified myself and my firm, based on the fact that the defendant is party to an indemnity and hold harmless agreement with an outside entity, an entity not a party to this lawsuit, and it was discovered by the plaintiff immediately before mediation, immediately within a week or so, that the individual who would be attending the mediation would be one and the same both for the comp carrier and on behalf of the defendant. And I should...
Well, I don't know, was the trial judge aware of the intended agreement?
Yes, but not the agreement itself. We filed the agreement, I think, after the hearing to be specific, but the truth be told, the actual document plays very little, at least from our perspective, in the decision of the trial court.
Well, can I clarify? You say the indemnity agreement that was put in after when you moved for a hearing, you say it plays no role?
Well, I think it does. It validates certainly the existence of the relationship between a party to the lawsuit and a non-party to the lawsuit.
Because my preliminary view of the case was that's your strongest point, that you didn't bring it up until the hearing.
Well, and I understand that. I do appreciate that.
I'm interested to get the other stronger point.
Okay. But let me tell you what I think my strongest point is, in all sincerity. In the different areas that we can attack the decision, I couldn't figure out which one to start with first, and certainly the existence of an agreement. There's plenty of case law out there. As I know the courts well aware, parties are free to contract practically anything they want. Uniquely, this is a situation where there's a party to a lawsuit contracting with an entity outside of the lawsuit, and arguably speaking, over whom the trial court has no control or jurisdiction because they aren't before the court. But more specifically, if you take the decision to its logical end, where's the cure? You kick my law firm off, which the trial court has decided to do by disqualifying us, and what has gotten better, what issue has been resolved? Because whether it be at mediation, whether it be at trial, whether it be in any settlement negotiations, whether it be post-verdict, whether it be involved in subrogatable workers' comp lien rights, the individual who's going to make that decision remains the same. And unless I'm mistaken, the court does not have the power to dictate to a non-party to a lawsuit who that individual will be, or if it's required to be more than one person. And I don't know how that decision cures that. You can kick me off and you can bring in a separate lawyer for the comp carrier, you can bring in a separate lawyer for the defendant, but the person behind the scenes who's really calling the shots remains the same. This decision doesn't cure what's alleged. Now,
I take your point. I think the problem comes back to the state of the record. When, to judge from the trial court's order, she was unaware of the substance of the agreement.
She was aware of the substance of the agreement. The actual document itself showing the existence of the agreement was not before her, but more importantly, and in compliance with all the case law, both an executed agreement and release and an acknowledgement by both the party to the lawsuit and the non-party to the lawsuit was filed before the court, indicating that they both consented to my involvement, my firm's involvement, even possibly aware of an alleged conflict of interest. But here's the unique part about it on top of it all. Where is the plaintiff standing? I have never represented the plaintiff. No one from my firm has ever represented the
But
plaintiff.
regarding the standing issue of the respondent to raise this issue,
Yes, sir.
isn't it true that the trial court could have raised the conflict issue on its own?
Absolutely. I think the court's free to do that. The case law is clear. Anytime the court believes that there is a concern over that, they are free to raise it. But still, and I know the court knows this all too well, the Supreme Court set out 2 prongs of a requirement to disqualify a law firm under allegations of conflict. Not difficulty, or they're making it difficult for me. It's, I've got to have represented them. And there is some information of confidence I've learned. There's a 2-pronged test. I haven't represented the plaintiff. No one in my firm currently employed there has ever represented the plaintiff. No former employee of mine has ever represented the plaintiff. Where is the standing in compliance with the Supreme Court's rule? And it doesn't exist. Uniquely, well, and I will say this, I think from a timeliness perspective, in all fairness,
But the standing is a red herring if the trial court can properly raise the issue, so it's fine.
well, and had that been something that the trial court raised on its own with some reason to believe that there was a conflict, but that's not what happened here. And that's what I was just getting ready to address. I don't think from a timeliness perspective, the respondent or the plaintiff at the trial court level did something in an untimely way. But the reality of what they represented both to the court and to this court in their brief is what this is really all about. And that is, as they stated in their brief, in a letter they originally presented to us, we won't raise the conflict issue if the individual holding the purse strings for the complaint will waive it.
Well, counsel, wouldn't you be somewhat limited in your ability to represent the employer lien holder versus representing the defendant, Anheuser-Busch proceedings?
I don't believe so. I don't know how I would. The only thing that's going on in this particular matter, from a behind the scenes, if you want to call it,
As counsel for the lien holder, would you be interested in getting the largest amount of the settlement in terms of proceeds from the settlement for your client?
wouldn't I be concerned about trying to get the largest amount? Oh, I would think so, certainly.
Now, as counsel for Anheuser-Busch, wouldn't you be willing to limit the amount of any judgment or any agreed upon amount for your client?
Well, agreed upon is a different issue, but certainly at the trial level, I would be trying to reduce that if that was the defense. But
How do you measure you?
I think that's great because it's in the Florida statutes. According to Chapter 440, there's a remedy already available to the plaintiff. In the event the plaintiff and the employee in this situation does not believe that the lien holder is working with them or is holding out for an amount that's inappropriate, what's the remedy? You go file an action to have that lien reduced with the court. The cure is already in place. However, we are dealing with, by any court's description, one of the most drastic actions a court can take against a party, and that is to restrict its choice of counsel.
You said the trial judge knew about the substance of the indemnity agreement, even though the trial judge didn't have it. Where's that? Where's it that?
It was explained that the individual, and he was specifically identified in the hearing, his name's James Gorley, and the relationship between the two was explained. He would be the individual appearing on behalf of the comp carrier because the plaintiff is the employee of the company for whom he works. He has an agreement where he is to indemnify and hold harmless.
Are you saying there's enough testimony about the relationships there that the trial judge should have known that there's a written indemnity agreement underlying it?
I don't know, and I'll be candid with the court, I don't know if the actual word written was referenced, and I would honestly have to go back and look at the transcript from that hearing, but the relationship of the parties was breached with the court, and she was aware of the fact that that's why Mr. Gorley.
But didn't you wait until after receiving the adverse ruling to inform the court of the indemnity agreement?
Yes, I'll candidly concede that. That was to provide the actual document.
Wait until after receiving the adverse ruling to inform the court of the existence of the indemnity agreement?
Of the existence of the document, the fact that there's a real document there, but the substance of it, the fact that Mr. Gorley was there on behalf of both, and the reason why was expressed in the hearing. The court knew that. But more importantly, Mr. Gorley, who's the individual involved here, works for an entity that's not a party to the lawsuit. And the court's ruling, in effect, tells a party to the lawsuit and a party outside the lawsuit that's not a party to it how they can or cannot be tracked.
Agreement attached to Mr. Corley's affidavit?
Sorry?
Was a copy of
Yes,
the
sir.
indemnity agreement attached to Mr. Corley's affidavit?
Yes, sir. After the original ruling, yes, sir. Yes, sir, it was.
So what's the standard we should be applying here? It's an issue that was raised for the first time or it was a document you rejected the first time on a motion for hearing, does that change the standard of review?
I don't believe it does, because I believe the way that the court is supposed to be addressing this issue is, as I've expressed, on three different fronts. One, is there an adequate remedy at law available to plaintiff already? Before, keeping in mind that you are being asked to exercise one of the harshest rulings that a court can impose on a party as it relates to their choice of counsel. With that standard,
this fact pattern is some of the usual facts.
are they unusual? No, actually not. In fact, this court has addressed it on more than one occasion, actually found two different particular cases that set the standard for review.
Any Florida law directly on point on this issue?
On this type of an agreement between a party and a non-party, correct. But the standard for disqualifying a law firm is pretty well established in this state. I think the fourth PCA probably rendered the fifth PCA in 2004 probably rendered the most comprehensive interpretation of the Supreme Court's decision in the KAW file.
Is the trial required to consider new evidence on a motion for review?
Is it allowed to? Yes.
Is it required?
Or is it required to? No. But is it permitted according to the rule? Yes, sir, it is. And like I said, all it did was validate the existence of what had been presented to the trial court at the hearing. And that's the issue. I'm sorry. I apologize. Thank you so much for this reminder. I'll sit down real quick. Thank you.
May I please support Brett Hastings on behalf of Christopher Staples in this case. And to address some of the good questions that the panel just asked of Mr. Fernandez, I think we started with the words that Judge Cole put in the order that disqualified his firm that I think really encapsulate what this case is about. She said the conflict, as we alleged, was fundamentally antagonistic, and it is.
But why is it antagonistic to you? What do you care?
The reality is, I found out about it as I was getting ready to prepare for the mediation because I wanted to.
But how does it tangibly affect you and your client?
We cannot speak with the lien owner and discuss, frankly, the real significant weaknesses that may exist in our case because we would discuss with the same trial counsel who would use those to lynch us. So those are fundamentally antagonistic, and that's why.
I see that in one respect, but at the same time, assume we affirm the trial judge's order of disqualifying counsel, you're now going to have two lawyers, and they're probably going to talk as well. So what's the difference?
At least
you're not saying there's anything wrong with the indemnity agreement.
I am saying there's something wrong with the indemnity agreement. I also believe there's a serious defect as how it was presented to the court at this juncture. Mr. Fernandez is one of the fine trial lawyers that we have in North Florida. I don't think he tried to deceive anybody as it relates to this case, but I do believe he has a clear conflict. In 15 years, I've never had to file one of these motions. I had to go and look through the law to discern what to do. I reached out to the bar before it began. And what was really important was the first thing that I did is I made a call to Mr. Fernandez's firm. They get a chance to speak with Mr. Fernandez.
That's when you asked them to abandon the lien.
Well, no. What happened was I got a notice of lien about 2 weeks before mediation. And I found out that their firm was representing them. I've been trying to get a hold of the lien holder, and I couldn't find anything out. I couldn't get an itemization of the actual medicals that I would need at the mediation. When I got the notice of lien, I said, I think we've got a problem here. How is this going to work? I called the bar. The bar said, you need to reach out to the other side, and it appears that there could be a conflict, and you need to analyze whether or not you need to file a motion to disqualify.
I'm sure you did everything in a very professional way. What exactly did the trial judge know when she entered her order?
Well, and that's a great question, Judge Benton, because I never heard indemnity when I spoke with their firm. Indemnity was never mentioned in any one of the letters that we got. And when we were at the hearing, there was never an indemnity agreement presented. There was an affidavit.
You disagree with the representation that she knew the substance of the agreement at the time she entered the ruling?
Absolutely, Your Honor. I had the benefit of arguing the hearing. Mr. Fernandez didn't have the opportunity to be there. He had one of his partners or his associates that were there. There was an affidavit from Mr. Gurley. There was a typo in that affidavit. Within that affidavit, it said that there was an existing conflict. They asked for the opportunity to cure it. I never saw an indemnity.
Was a copy of the indemnity agreement filed in support of the motion for review?
Not only was it not filed, it wasn't mentioned. There wasn't a discussion of indemnity at that time. The discussion of indemnity and I've gone back to review the record to look through these issues as well, nothing was discussed until the motion for rehearing. The affidavit does not attach an indemnity agreement. I was writing along with my co-counsel in this case, Philip Kinney, to get a copy of that indemnity agreement. And what's important to understand is the reason that we believe the trial court's order should be affirmed is there's a written indemnity agreement, but what's important in the indemnity agreement is on page 6, it says, except as set forth in subsection 8E, the foregoing indemnity shall not apply to the extent of the shipper's gross negligence in the cause of such claim. So gross negligence, shipper, Anheuser-Busch, who we're suing for their negligence, is specifically accepted. And then if you come down farther in 8D, it says, goes through all the indemnity language, but again it says, accepting only claims resulting from or caused solely by the negligence of the shipper, Anheuser-Busch. Our complaint, as it clearly alleges, is negligence against Anheuser-Busch. Down here further, as set forth above, accepting only consequences resulting or caused by shipper's sole negligence. There's a written agreement that says indemnity, but there's a carve-out for this specific case. So the indemnity agreement, and I brought additional copies if the panel would like to see those. And I've got one for counsel.
I mean, did this ever end up in the record below after the petition for service filed at any time?
I'm confused as it did or didn't. I believe when there was an amended petition, there was an initial petition for a writ of cert. I was trying to ascertain whether or not it was there. The court did not find out about it. I did not have an opportunity to analyze it, and that's also why
the appendix to the amended petition, that's the first time that you saw it?
I believe so, yes.
So in other words, this indemnity agreement is not a part of the record.
Absolutely. And even if it were a part of the record, it kills.
You say it doesn't cure the conflict.
It doesn't cure the conflict. And the reason we know that's important is because the time to determine whether or not you have a conflict is when you take the client on and you get involved in the case. So if one client says they have an indemnity agreement, there surely should be a discussion. And so that's why, in answer to your question, Justice Benton, is that there was no discussion up front. It's not in any of the letters, which are all part of the record. And I don't want to kick anybody's law firm off of this. I'm a plaintiff's lawyer. We don't get paid till the end. I desire closure, and I desire seeing justice for my client. But once confronted with this, I thought there was nothing else I could do. So I did say, if you want to waive the lien, and I can get my client to closure, I would gladly do that. They didn't want to waive it, and so it found us in this posture. I felt after looking into the bar, looking at the cases of this court, I had no
Let me answer
answers.
this question. Last I knew, in the marital context, one lawyer could represent the husband and the wife, provide those disclosures, and there's an agreement that the lawyer will handle the disposition of the marital property and the non-marital so forth. Let's assume, why is it any different? Where are you harmed? Because here, his clients have said, it's okay for you to represent both our interests, much like the husband and wife. And let's say there's a vendor who sold something to the husband and wife, who now is in your posture and wants to sue them to get money on that. And where are you harmed by the fact that he has joint representation of two clients who otherwise would have a conflict? I'm struggling to see the harm to you.
In how it
Versus
is,
one lawyer versus two. I mean, I think you're worse off perhaps because now you'll have to deal with two lawyers.
well, the entire system of justice is premised on good faith, fair
Harm to your client.
Right. Well, under that scenario, Justice McCart, he could be the plaintiff and be the defendant in both written consents. Judge Cole would no longer be a judge, and he would no longer be a lawyer. He would
That's
be
called
a
settlement.
Right. But but it's called a mediation. Because what happens is the adverse interests don't have an opportunity to play out, and really, at its core, that's what justice is.
I'm still waiting to hear something tangible as to your client.
Well, I at least know what representations they make to me, and I can then relay this to my client and give them advice. Whereas when I go into the same decision maker who can deal on both sides outside the top, I believe that my client is specifically harmed and prejudiced because we won't get to the bottom line number. We won't be able to truly work through and resolve the lien in the other. If I had a frank discussion with him about the weaknesses in my case, I could get a better result for my client. So if I can't have that fair and frank discussion with a lawyer who's going to have undivided interest to his client, I believe that we're prejudiced by not getting to the lowest and best number. And at a minimum, at least we know it was done within the fair constraints of the law, as opposed to, I think he's being fair, I hope he's being fair.
Counsel, assuming a copy of the indemnification agreement had been filed during the course of the hearing, marriage hearing, on the motion, then would that have changed the trial judge's reasoning in the trial court?
No, I think it would have made the judge feel even better about her order, would have made it swifter, and she would have concluded it, because this indemnity agreement, okay, the reason this indemnity agreement is brought up in the brief, the reason that each of the justices here have gone to the heart of the indemnity agreement is because it potentially, theoretically addresses the elephant that's in this room. And what's in this room is that there is clearly an adverse relationship by representing the lien owner and the premises owner in this case. So if it were the same money or the dollars, then it would probably go to addressing Justice McCarr's issue of what's the real prejudice as it relates. But when there isn't an indemnity agreement, then what's somewhat acknowledged in the brief by the Fernandez trial firm is that, hey, okay, there's a conflict, we discussed the conflict, they consented to the conflict, but yeah, you know what, here's where you can feel good about it, here's this indemnity agreement. The indemnity agreement wasn't presented to the court, and then once we had an opportunity to see the indemnity agreement, we would have loved to argue it at the trial court level, because it clearly, unequivocally shows that it isn't really an indemnity agreement for negligence against, as alleged by us, against the Anheuser-Busch.
Would you agree that this qualification of a party's counsel is an extraordinary remedy and should be resorted to sparingly?
Absolutely. And that was why I indicated this case law was new to me. I had to deal with it, and quite frankly, I didn't want to file it. I hoped that the phone calls that took place before would have resolved it. I was hoping that we would be able to resolve it before we got to that juncture. But at the end of the day, I felt as a member of bar, I was commanded to do it as a zealous advocate for my client. And the one thing that I would point out in the brief that I think addresses some of what Justice Benton as well as Justice McCarr could address is in this court's holding, of which Justice Benton was on the panel, Lincoln Associates versus Wentworth Construction, and that's 26 Southern 3rd 638. And in this case, the court found the concurrent representation of two parties in the same action gives rise to an irrefutable presumption that confidences are disclosed during the course of that relationship. And so I think that addresses to a certain extent what Justice McCarr was bringing up, that I don't know, but going through the footnote language of 417 and
the opposing counsel's point is that he never represented your client, but he has not had the benefit of any confidences, presumed or otherwise, that your client disclosed. That you are essentially met, that what has been worked out between these two parties is none of your business.
And I agree, it was not specifically defined. I believe that there's an adverse interest, and if we could, and we talk about the idea of fundamentally antagonistic, that there is a fence, and that the employer and lien owner, and trying to maximize the recovery, because that's what it's all about. If he's zealously advocating for one of his clients, he's trying to get the most amount of money from my client as possible.
Up to the lien.
Correct. Meanwhile, he's trying to pay zero. He wants to come in and be in this courthouse, will be here 3 or 4 days, and he wants to walk out with the zeros, we to the plaintiffs and come out. And so, really, the core of those issues, and generally, I tell you as a plaintiff's lawyer, the amount of medicals are contested, but most of the time, especially medicals in the past, are relatively certain, so the issues go to the heart of liability, and that's really where the discussion would be frank. I call up lien lawyers all the time and discuss where the real problems are in our case, where the skeletons are hidden, where someone can make hay in front of a jury, and that's the concern here.
But you don't have some entitlement to the benefit of another party's lawyer's work.
I agree.
So exactly what is the harm to your client?
The harm to the client is, if I were doing my job for the client to get the lien brought down as far as it goes, I would disclose things to the same attorney and to the same firm that would kill my client before a jury in the prospective case. So that is the harm. I'm put in a box of having to attempt to take one action as part of my requirement as an advocate that will hurt my client somewhere else. So that is the harm.
But that arises out of the relationship between the two parties on the other side, or if one is not in the lawsuit, as you say.
Well, and with all due respect, I think fairly, as the trial court judge got right, she wrote an incredible 14-page opinion. She labored over this intensely. At the end of the day, it is fundamentally antagonistic. There is a clear conflict that exists here. If we didn't bring it up, she would have brought it up. But at the end of the day, there isn't any other way to address it at this time. I wish there was. I don't take any joy in trying to take Mr. Fernandez out of this case. I don't like writing appellate briefs. I love the opportunity to argue before each of you and the fact that you came here to Jacksonville to do it. But this isn't efficient as it relates to the administration of justice. But at the end of the day, I can look my client in the eyes and say that we did it right, we did it all the way, and that we have a fairly certain result, and that I believe that I gave him my best shot.
Do you agree that an indemnification agreement could moot the issue presented in this case?
You'd have to get into the structure of the indemnity agreement. Potentially, I do think it could. I think a fair reading of this agreement doesn't allow it, and that's one of the reasons it wasn't mentioned or wasn't part of the record.
With your permission.
This is very fundamental. We're just told that the trial judge never got the agreement or was informed of the substance, and that the agreement only surfaces as part of the appendix to the amended petition for writ of certiorari.
Right.
And the suggestion was made, and I hope you will address it, that was deliberate, because if you examine the agreement, the way it's written, it accepts gross negligence and accepts this scenario. And it doesn't apply anyway.
And I certainly appreciate that concern, but that's not the case. In fact, I just went back and was looking at the transcript from the hearing itself, where the long-standing relationship between CCC and Anheuser-Busch was fully explored. And in addition to that, that long-standing relationship is actually mentioned, I think, in paragraph 11 of their motion to disqualify. This is not news to anybody. This existing relationship between these parties was not there. Furthermore, gross negligence is being a concern over not producing the actual document at the original hearing. This is not a case of gross negligence. It's a slip and fall case. It wouldn't apply anyway if that was a concern. So factually, that's a moot point. But the fact that these two parties, or one party and a non-party, had a long-standing relationship is actually mentioned in their motion to disqualify. It was discussed in the hearing. In fact, it was even brought up by Mr.
So that's as specific as it got, that there exists a long-standing relationship.
With the added representation to the court that Anheuser-Busch had long had a relationship with CCC where they allowed CCC to come in other cases and negotiate on their behalf at a mediation while protecting the employer's workers' compensation lien as well. All of that was brought up in the hearing. I just went back and looked at it. And again, it was quoted in their motion.
How do you feel that you could zealously represent a client, the lien holder client, at the mediation, as well as zealously represent the defendant in the proceedings, during a mediation proceeding?
Right. And if there were two different accounts that were going to pay those two different amounts from two separately and administered, whatever you want to call it, claims managers, representatives, or whatever, I could see arguably where that would put me in conflict, but we don't have that. In this situation, we have arguably two payors to the plaintiff coming out of the same bank account. No matter whether I represent them or a host of 20 lawyers comes in and represents as many different interests as we can pretend exist, there is but one. And it is coming from the same account, and it's administered by the same individual. I am not in conflict with that individual at all. Furthermore, as the court knew, there was a waiver of any potential conflict, both by someone on behalf of CCC and on behalf of Anheuser-Busch. What I don't understand is how the plaintiff is presenting a conflict of interest with those parties. Everything they do is of conflict of interest with the plaintiff. If the lien order was truly an independently managed account, they would have by law a right to demand every single penny be paid back. And the other entity that's not a part of the lawsuit, well, excuse me, that would be through Comfort, but Anheuser-Busch would still have the ability to challenge and be as antagonistic and as adverse as it wants to be to the plaintiff by trying to keep the damages as low as possible. Everything, regardless of who represents them, is going to be adverse to the plaintiff. But this is coming from one account. One account only. And I don't know how a court can look at a non-part.
You say that on the basis of the agreement you were unwilling or unable to give to the trial court.
I will candidly tell you that we did not believe that the actual document or the terms of the agreement were an issue before the court. It was more an issue of standing because they were raising a rule in the Professional Conduct Code involving representation of a client. This was not a challenge to, oh my gosh, I've got an adverse interest with the defendant. Well, of course you do, in everything that they do.
But it was a tax court decision to withhold the agreement, and now you're standing on the agreement, which was never before the trial court.
Well, and I respectfully disagree. It was. The relationship between the parties was discussed, a long-standing relationship, the fact that a non-party was routinely allowed to negotiate on behalf of a party, and that was brought up both in their motion and in the hearing. It's in the transcript. It wasn't a tactical decision not to bring it in. It was simply a belief that it wasn't an issue. The terms of it weren't an issue. This was the right of a non-party to come in and negotiate on behalf of the lienor and a named defendant, and that was the only issue we were being informed was the basis for the disqualification. I was being challenged on a conflict of interest with a client, and we don't have that relationship. Not with this plaintiff, ever.
But do you agree that an indemnification agreement could have mooted out any potential disqualification issue?
I certainly think that it could have, and arguably speaking, maybe should have made it moot, and that's why it was presented subsequently, as we pointed out before. The court's not required to consider information post-decision.
It would have been in a better position to trial court had it been admitted during the hearing itself.
Agreed. And had we known that that would have been an issue, we would have gladly and quickly produced it. We really didn't think that was the issue before the court. That's not what the motion was challenging. The motion was attacking my involvement, my firm's involvement, on the basis of I had a conflict with a client. And we don't. I'll keep talking if you want. I'm sure you've got better things to do. All right, thank you.